Get back in the car. Get back in the car. Get back in the car. You know what? See what you doing? What are you stepping out of the car for? Hey, stop. Put your hands behind your back. Hey, what are you doing? Hello? Hey, what are you doing? Hello? One to ten. Go. Hey, stop. All right.
240, you can show me pulling up 26 of March 20.
Hey, look, stop. I ain't playing with you, dude. I'm not playing with you. Stop resisting. Stop.
Sir.
This probably, you can't hear it. Stop. All right? Stop.
Sir, I'm handcuffed. You need to relax.
You need to relax. Stop resisting.
I'm not resisting. I'm handcuffed.
Stop resisting.
Yeah, you
lay on top of the hood.
Over, sir. Hello?
Hey, look, you gotta go on the ground if you don't listen.
Why you keep doing this?
Stop! I said stop!
Bro.
Stop resisting. Why you tensing up for? Why you tensing up for?
Bro.
Why you tensing up for?
Why did you pull me over? Hello? I'm handcuffed. What is the problem, bro?
Hey, roll over. Roll your stomach.
Check the north 120. Can you at the north 120?
Oh, 120 left.
Hello?
Before you work those heads, you slow down.
Sir, you can't get something for no reason. Why not?
Hey, boss, right now, just chill out, all right?
You can't tell me to chill out if I'm not being told I'm being pulled over. Hello?
When we get you in the back of your car and we're done with this search, you will be told what's going on.
What am I being searched for? Hello?
Well, you're being arrested, boss. You're arrested.
For what?
You're under arrest.
For what?
We'll get to that. Just calm down.
How you gonna tell me that? You didn't even tell me why you pulled me over.
Almost got me hit by an SUV.
I got you hit by an SUV. It doesn't make sense.
Why you have to step out your car? I didn't ask you to
Is it
step
illegal
out.
to step out my car?
Yes, it is.
It's illegal to step out my car?
You're not being told to step out your car. So you wait in your car until I come up to your car. Then
I didn't know that. So what's the problem, bro?
And then I'll tell you why I pulled you over and what's going on with you.
You just okay if you just pull me out of my car and just pull me on the ground.
How did I pull you out of your car when you just stepped out of your car?
You just said don't
We're done, man.
Why am I being searched?
Because you're under arrest.
For what? What am I being arrested?
Obstruction, reckless driving. How about that?
Driving? Are you serious? I didn't use my turn signals?
I was traveling at 72 miles an hour when you passed me on the very last lane, the very left lane. That's the reason why I'm pulling you over. All I was trying to do is trying to figure out why you were going that fast.
I wasn't speeding.
All this, yes.
How fast was I going?
I'm doing 72 miles an hour.
How fast was I going?
Listen.
No, you can't tell me to listen, bro.
Then exercise the First Amendment then.
But you just pulled me on my car.
Exercise your First Amendment.
You're not telling me why I'm being pulled over?
The discussion for this is over.
It's not the discussion, bro. You're not telling me why I'm being pulled over.
Yeah, you'll see it in court. I'll see you in court.
So where's my stuff? Like, why am I being pulled over? I still don't understand.
You'll know in court. Roll on your butt. Roll on your butt. Put your feet up to your chest. Put your feet to your chest and up.
Am I getting arrested?
No, you're trying to check on now. I'm going in custody. Didn't I just tell you you're under arrest?
Bro, if you're saying that I was speeding, you give me how was I speeding, sir?
Sit in the car.
The officers inform Mr. Thomas that he is under arrest for obstruction and reckless driving. Section 40-6-390 of the Georgia Code states that an individual commits the offense of reckless driving if they drive a vehicle in reckless disregard for the safety of persons or property. In the 2003 case of Frazier v. State, the Court of Appeals of Georgia concluded that speeding alone can support a conviction for reckless driving, even when unaccompanied by other traffic violations if the defendant was driving at an excessive rate of speed, given the speed limit and the driving conditions. Accordingly, if a court believed the officer's testimony regarding Mr. Thomas's speed, it is possible that he could be convicted of reckless driving. Now, as for an obstruction charge, Section October 16th, 24 of the Georgia Code makes it a misdemeanor offense to knowingly and willfully obstruct or hinder a law enforcement officer in the lawful discharge of their official duties. While it is generally recommended that drivers remain in their vehicles during traffic stops, there is no specific Georgia law that prohibits motorists from stepping out of their cars. Accordingly, a court would likely find that Mr. Thomas's decision to exit the vehicle at the beginning of the traffic stop did not rise to the level of obstruction. However, the analysis changed once the officer ordered Mr. Thomas to get back into the vehicle. Georgia courts have repeatedly held that an individual's refusal to obey an officer's lawful command can constitute obstruction. For instance, in the 2005 case of Turner v. State, the Court of Appeals of Georgia determined that evidence that the defendant repeatedly exited his vehicle in violation of an officer's orders to remain seated in the vehicle was sufficient to sustain an obstruction conviction. A court could conclude that Mr. Thomas's failure to get back into the vehicle when ordered constituted obstruction, and that it was a refusal to obey the officer's command. However, in this situation, the officer gave Mr. Thomas very little time to comply with his order. In the 1986 case of Coley v. State, the Court of Appeals of Georgia found that evidence that an individual failed to respond immediately to an officer's orders was insufficient to support an obstruction conviction. As such, Mr. Thomas could potentially argue that the officer did not give him enough time to comply with the order to prove knowing and willful obstruction.
Well, I'm glad I was heading up this way anyways. I pull up and all I see is you can read them from over there all the way over here, and I'm like, oh boy. DUI, I could smell alcohol coming from his breath. Well, if you want to do that, I'd read them in implied consent right now. You have a card? Yeah, I do. Okay. Yeah, check the car thoroughly. Because I also smell weed coming from there, but I don't know if he smoked before or whatever the case may be at this point. Like you said, how fast you were going, if I had to guesstimate, probably 90. Listen. Hey, that lane, there's 4 lanes.
No,
look,
sir.
Listen.
You're telling me to listen, but you're not listening to me, sir.
I got nothing. All he's got is he just got the paper for the rolls. That's it.
None of the bottles smell like alcohol or anything like that. Right now, and everything's good on the car.
No valuables, nothing. I don't know where his phone is.
Okay.
Do you have your phone in the car?
When I was thrown against the hood of your car, I don't know where it went, sir.
Where is that?
After I was thrown against the hood of your car, I don't know where it went, sir.
Okay.
Hey, what's my charges again, sir?
Obstruction, reckless driving. I'm debating on DUI less safe because I do detect an odor of alcoholic beverage coming from your breath. So I don't have a PBT to see if you're positive or negative for alcohol in your system. So we'll go with that.
We'll go with what? There's only 2 charges, or is it 3?
And that's your phone. Go ahead and cut his car off.
2 charges, or only 3?
Okay, cool. What'd you say?
You said there's only 2 charges. You said reckless endangerment.
Reckless obstruction, and I'm debating on the 3rd charge right now.
You said reckless obstruction.
Reckless and obstruction.
Oh, reckless and obstruction.
Yes.
Okay. Gentlemen, can I ask you guys a question?
I was pulling up.
You said it was illegal to get out my car during the traffic stop?
Yes, because you weren't ordered to get out your car.
No.
See, this is what would have
See, you
happened.
just keep talking. I'm trying to ask you a question. Is it illegal?
Can I explain what would have happened?
No, I just want the law. What law says it's illegal to get
Again,
out my car?
because I didn't give you a lawful command to get out your car. All right? So this is what would have happened. I would have pulled you over for speeding. I would have had a conversation with you, told you to slow down, because it's dangerous the way you're going by people. You're traveling faster than the traffic. And I was doing 72, and you passed me, probably doing 90 on the very last lane. So I would just had a conversation. I wouldn't even written you a warning or anything. I would have just let you go.
Disrespectful? I didn't do anything. I just stepped out my car.
Again, you cannot step
No,
out
but I
of your
understand what you're
car.
saying, but I didn't know. You're just getting mad at me for what? I don't
Again,
know.
but when I tell you get back in your car, that's still a lawful command to get back in your
I'm turning
car.
around to see what's going on, and then getting thrown on the floor. I don't know what's going on.
And again,
Wow.
that's why you give me the opportunity to explain why I stopped you.
So what happened? You just
So I was all the way in the second lane, real closest to the wall, and I was going about 72 miles an hour when I looked down, and he was coming up fast.
I'm just talking about the UOF. That's all.
Okay, no, everything is cool.
You had to take him down.
Yeah, because he wouldn't get back in his car, and then when I told him to put his hands behind his back, he still was resisting, trying to figure out why I pulled him over. So like I just went ahead and tried to cuff him. When I cuffed him, then he was tensing up his body, still being resistive. So I took him to the ground from that point.
All right.
So yeah.
The one thing, I know I heard y'all call ATO.
Yes.
If he wants to leave his car here, he can. If he wants somebody to come pick it up. But unless you just want to.
Yeah.
We don't have to just arbitrarily impound it.
I know. But
Okay.
yeah, no.
All right. So does he want to leave it here?
I didn't ask him. I'm going to impound it anyway.
Just ask before you tow it.
Okay.
If he wants to leave it here.
Alright, so I'm going to read you something. Just please confirm your age for me. How old are you?
30 years old.
30 years old? Okay. Alright, I'm going to read your implied consent rights, alright? Because I'm pursuing DUI charges against you. Because again, like I said, I detect odor of alcohol beverage coming from your breath. That's what this is.
What is that?
This is I'm reading your rights on that. So you have a choice whether to take the breath test or not. So once I read your rights on that, and you'll inform me that you understand it, and then from there you can make your choice. All right, I'm gonna read your implied consent for the state of Georgia. Will you submit to the state-administered chemical test of your breath?
I want to do blood.
Excuse me?
I want to do blood.
Okay. So right now I'm reading you for breath.
No, you said you could do blood.
Yeah. So it's either yes or no at this point, and then I'll reread it for you for the blood, because I have for every little test I have to reread this and then mention the test. So would you go for your breath?
I do for blood.
It's either yes or no.
I said yes for the blood. You give me 3 options.
Listen. It's not because I have to reread it for blood. So I'm going to read. Yeah, that's what I'm gonna do. But for your breath test,
No, I'll do the blood.
again, it's either yes or no.
I'll do the blood.
Listen. It's either yes or no for each test that I read for you. I understand you want to do the blood, but since I asked, and we'll get to the blood. But again, I have to reread this card. Okay? So it's either yes or no for the breath. What would?
I don't want to say yes or no for the test. I was going to say yes for the blood. If I say no, then you can say, hey, I didn't read it.
No. I told you I have to reread this. It's still your choice. So that's what I'm saying. I still have to reread this. And when I mention blood, then you make your choice there too. So for the breath, no.
Mr. Thomas says that he does not want to take a breath test, but he agrees to submit to a blood test instead. Under Georgia's so-called implied consent law, which is found in part in Section 40-5-55 of the Georgia Code, when a driver is arrested for DUI, the resisting officer can request a state-administered chemical test of breath, blood, or urine to check for alcohol or drugs. A driver has the legal right to refuse the test, but doing so carries administrative penalties, such as a driver's license suspension. It should be noted that according to Georgia law, the requesting officer has the authority to select which test or tests to administer in a DUI case, and the driver does not have the authority to request a different test instead without it being considered a so-called refusal. Therefore, in this situation, The officer determined that he wanted a breath test, and Mr. Thomas did not agree to take that test. So even though he consented to a blood test, a court could potentially find that he quote-unquote refused the breath test under the implied consent law. However, the statute only authorizes officers to request chemical testing when they have probable cause to believe that the person has committed a DUI offense. Here, the only evidence the officer cited to support the DUI arrest was the alleged odor of alcohol on Mr. Thomas's person. And in the 1989 case of Clay v. State, the Court of Appeals of Georgia determined that the mere fact that a driver had an odor of alcohol on his breath was not sufficient on its own to give rise to an inference that he was intoxicated. Accordingly, if a court were to determine that the DUI arrest was not based on probable cause, a court would also likely determine that the officer did not have the legal authority to request chemical testing, and therefore that Mr. Thomas's license should not be suspended for his apparent refusal to submit to breath testing.
For blood. The state of will you submit to the state administered chemical tests of your blood? Okay. But as soon as I saw him, I moved him to the front of my car, I think, or to the front of his car. And thank God he didn't strike none of the cars.
No doubt.
I have to get you medically cleared before I take you to jail.
Say one more time, sir.
I have to take you to the hospital, get you medically cleared before.
The officer explains that he has to take Mr. Thomas to the hospital to get him medically cleared before he can take him to jail. The Supreme Court has determined that police officers who injure an individual during an arrest have a constitutional duty to ensure that they receive medical care. For instance, in the 1983 case of City of River versus Massachusetts General Hospital, the court held that the 14th Amendment's Due Process Clause requires authorities to provide medical treatment to individuals injured while being apprehended by police, which may include seeing that an arrestee is taken promptly to a hospital and ensuring that the needed medical care is provided. Accordingly, in addition to the department policy the officer referenced, a court would almost certainly determine that he had a constitutional obligation to ensure that Mr. Thomas received medical care for his injuries.
Yeah, she's gonna come pick up the car.
Okay. I'm probably going to do obstruction on city. Just keep it all in-house because I think we could do reckless. What? I think we could do reckless, and I know we could do DUI in-house. So I was going to keep it in-house, all these, because it's traffic charges and that city charge of obstruction.
Yep.
So
Smyrna?
Yeah.
Okay. Well, I told her Fulton, but whatever.
Yeah,
Go call from Smyrna.
Yeah.
What does that mean?
You'll be charged with the city ordinance of obstruction, and then state charges on the traffic citation
I know what you're saying, but what does that mean? City charges and
so that way you'll go to court here instead of going to court in Atlanta, because that's where the Fulton County court is.
Mm-hmm.
So instead of going to state court,
you're doing Sandy Springs.
Yeah, I'm doing all in Sandy Springs. So again, that kind of saves you a trip, and I'm assuming that's your correct address on your license. No, I'm saying is your current address. Yeah, okay.
The officer explains that he's going to charge Mr. Thomas under a city ordinance rather than the state obstruction ordinance. Although there does not appear to be a local so-called obstruction ordinance, the city's so-called disorderly conduct ordinance, which is found in section 38 to 54 of the Sandy Springs Code of Ordinances, includes in its definition of disorderly conduct interfering with another's pursuit of a lawful occupation by acts of physical obstruction and remaining in a street so as to impede the flow of traffic. It is not evident which of these subsections the officer decided to charge Mr. Thomas with violating, and neither seems to clearly apply to his behavior.
You can head out and I'll hang out at the car for a little bit until we get some calls coming through, and then if she's not here then I'll just leave the car with the keys in it.
Is it secure and all that?
Door accused.
Is it secure?
Was that?
Is it secure? Is it secure?
The car?
Yeah.
No, car's still unlocked.
All right. And you want these set of keys to go with her?
Yes, ma'am. Yes, sir.
Put them with it. I wouldn't leave the keys in the car. I just stand by with it.
Okay. Well, I'll just hang out until she gets here then.
Okay. If you have to go, where's his phone at? Because I would rather her to call us so that way we can meet with her and give her the keys.
Yeah, we'll do that. All right.
Mr. Thomas ultimately consented to the blood draw and was then taken to jail and charged with DUI. reckless driving, and disorderly conduct. He remained in custody for 6 hours due to the jail's DUI policy. According to Mr. Thomas, the test later revealed that his blood alcohol content was 0.02, which is far below the legal limit, and no other drugs were present in his system. Following the interaction, Mr. Thomas hired an attorney, and the criminal charges were ultimately dismissed. Mr. Thomas is still considering whether he wants to pursue a civil claim, but he is open to discussing his case with any civil rights attorneys that might be interested. Overall, the Sandy Springs officers get an F for escalating a minor traffic stop into a physical altercation, needlessly forcing Mr. Thomas to undergo a blood test, and for demonstrating a poor understanding of Georgia's implied consent law. Now, while the stop of Mr. Thomas was ostensibly supported by a claim of reckless driving, which under Georgia law can be substantiated by speeding alone, the conduct of the officers quickly deviated from routine protocol to unmitigated escalation. According to the officer, Mr. Thomas was arrested in part for obstruction, but based on the relevant case law, obstruction in Georgia requires a knowing and willful act of interference. The brief delay in Mr. Thomas's compliance, coupled with the officer's failure to provide adequate time to respond, would likely fall short of meeting that legal threshold. Courts have held that refusing a lawful command can constitute obstruction, but the officer gave Mr. Thomas almost no opportunity to comply with the instruction to return to the vehicle before forcefully handcuffing him and throwing him to the ground. The body camera footage shows that Mr. Thomas did not physically resist the arrest at any time, and when he was thrown to the ground, he was merely attempting to communicate with the officer. This level of force could certainly be seen as excessive by a court, especially considering that Mr. Thomas was handcuffed at the time. The officer's handling of the DUI investigation was also highly flawed. The only evidence cited to support the DUI arrest was the alleged odor of alcohol, which the Georgia Court of Appeals has determined is insufficient on its own to establish probable cause. No field sobriety tests were performed and no additional indicators of impairment were observed. Despite this, the officer demanded a breath test under Georgia's implied consent law. When Mr. Thomas declined a breath test, but agreed to submit to a blood test, the officer failed to adequately explain that a refusal to take the requested breath test, regardless of willingness to take an alternative test, would still be considered a refusal under Georgia law. Not only did Mr. Thomas appear confused, but the officer himself seemed unclear about the legal standards that he was attempting to enforce. The conduct of the Sandy Springs officers demonstrated a clear lack of sound judgment, poor legal reasoning, and an overreliance on force in a situation that could have been resolved with a verbal warning and clear instructions. This interaction highlights how a lack of discretion, poor communication, and questionable legal judgment can escalate a minor infraction into an unnecessary and potentially unlawful use of force. Mr. Thomas gets an A- because although the decision to exit his vehicle was extremely risky, he remained relatively calm and collected throughout the encounter, obeyed the officer's commands to the best of his ability, and followed up this interaction with the proper legal action. There's no denying that immediately exiting your vehicle upon being stopped by the police is abnormal and highly dangerous, especially on the narrow shoulder of a busy highway. However, as mentioned before, it is not explicitly illegal to do so, and the officer's response was completely unjustified. After speaking with Mr. Thomas, he offered some insight about his decision to exit the vehicle and why he didn't immediately comply with the officer. According to Mr. Thomas, he exited his vehicle because the windows weren't functioning properly, and he knew that he would be asked to exit anyway. After getting out of his car, he wasn't immediately able to hear the officer's commands because there was music still playing in his headphones. By the time he realized what was happening, the officer was approaching him with an unholstered weapon, and he froze in place so that he wouldn't be perceived as a threat. Now, while this does seem like a plausible explanation for his actions, I would caution anyone in a similar situation to remain inside their vehicle during a traffic stop until explicitly ordered to exit by the officer conducting the stop, regardless of whether there is some barrier preventing effective communication. While Mr. Thomas's behavior was not ideal, it did not rise to the level of criminal obstruction or disorderly conduct. His hesitation and confusion were exacerbated by poor communication from the officer and the rapid escalation of force. Mr. Thomas was ultimately able to have his charges dismissed through hiring an attorney, and I commend him for following up this encounter through the courts and proving his innocence. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.